Our breaking news story, of course, is that the NPA has decided not to go ahead with corruption charges against President Jacob Zuma. It is, however, going to appeal a High Court ruling which found that the decision to drop those charges in 2009 was irrational. Let's get some analysis on this. We're joined on Skype by Professor Pierre de Vos for more insight. Thanks so much for your time. What do you make of this decision, Professor?
Well, from the press conference at least, and the reasons given for the appeal, from a legal perspective, it seems a little bit bizarre actually, because the legal point on which they're going to appeal to the Supreme Court of Appeal has actually been settled by the Supreme Court of Appeal. So unless they were going to appeal to the Constitutional Court about whether a court should involve itself in questions of whether there can be a fair trial and so on, I'm not sure why they are appealing at all to the Supreme Court of Appeal, who has already, on a legal basis, settled this legal matter on which they claim will be the main basis for the appeal.
Our reporter Karen Mon posed that question to Shaun Abrahams, and he said that it was totally different issues based on facts. Two of the reasons he gave was that the judgment basically takes away power from prosecutors, and that is a question of independence that's being raised. And then also that, it seriously affects the separation of powers. Are those two grounds that they can actually win this case on?
I'm always very nervous to predict any outcome of any court case, especially if it hasn't yet been argued. But I would be extremely surprised if the Supreme Court of Appeal is going to allow the appeal and is going to make grant the National Prosecuting Authority's application, just because they have already discussed these matters. And they've said that, of course, there's independence of the NPA is very important, but that the exercise of power, also that by the prosecuting authority, is reviewable, and that it has to act rationally, and so forth. So, yes, once again, unless the SCA changes its already decided case law, I can't see that it's going to be successful.
What does it say about the full bench of the High Court having unanimously come to this decision that it was irrational to drop the charges in the first place?
Well, there's nothing wrong with appealing a decision even from a full bench of the High Court. It's one of the ways in which our courts are being held accountable, is exactly that there's an appeal process, and higher courts can come sometimes to a different decision from the lower court, even if it's a full bench. The question would be, on what basis? Is there actually a legal basis for it? We will have to see, of course, whether the full bench of the High Court will grant leave to appeal, given the fact that some of the grounds for leave to appeal have been settled by the Supreme Court of Appeal. But in principle, there's nothing wrong with appealing even a judgment of a full bench of the High Court.
Now, Shaun Abrahams was, of course, at pains to point out that the NPA is independent, that it's not filthy or corrupt, as he put it. Of course, public opinion after this decision is going to be otherwise for some people.
Yes, the thing with independence is it is about facts and it's about perception. We don't know what the facts are. I have no idea whether the NPA and the head of the NPA have been motivated by any other factors other than legal factors. But perception-wise, given the fact that the arguments that have been presented today in the press conference seem to be legally on very thin ground and very shaky ground, the perception will arise, especially with those of us who are a little bit informed about the law, that this decision wasn't taken for legal grounds, and that is not good for the NPA. So whether that in fact is the case, I have no idea, but perception-wise, I don't think this was very good for the NPA today.
Now, he also said that, he did this in consultation with senior and junior counsel as well as members of the National Prosecuting Authority. But when quizzed about exactly who he spoke to, he said it would be improper for him to disclose that. Is it improper for him to disclose who he spoke to, especially since he wanted to emphasize the fact that he consulted with other people?
Especially where perceptions are a problem, I think it's always good for the decision maker to give as much information and as much detail as is necessary. As there's no client and lawyer-client privilege involved in this case, as far as I can tell, I cannot see why it was not proper for him to have to say who he consulted with. One suspects, of course, once again, the perception would be that he might have consulted with members of the NPA who themselves are facing some serious criticism, like his deputy. So whether that is true or not, I don't know, but I would suspect, given the perceptions that are out there, that that would be a question to pursue.
All right, thanks very much for your time. We appreciate it. It was legal expert Professor Pierre de Vos. Now, more on the NPA's decision to appeal the court ruling on the spy tapes after this short break. Stay with us.